You remember when Sean Combs and his lawyers were trying to get copies of his alleged sex tapes in his criminal case? Well, the judge just made a decision on that. Welcome to Sidebar presented by Law and Crime. I'm Jesse, Music Weber. Hey everybody, this is another Law and Crime legal alert. So the Los Angeles wildfires.
Hey everybody, this is another Law and Crime legal alert. So the Los Angeles wildfires are still making an impact, and it's estimated that these wildfires caused more than $250 billion worth of damage. The loss of life is immeasurable. And there are reports, though, that insurance companies canceled thousands of homeowners' fire policies in the months before the wildfires. Were those cancellations even legal? Will insurance companies be able to help people recover everything that they've lost? Well, Morgan & Morgan, America's largest injury law firm, is here to help.
California wildfires, they were there in Maui, and now they're here for you and the families affected by these horrific fires. So if you've lost loved ones, your home, business, property, because of the Los Angeles wildfires, you can visit forthepeople.com LCF. Fire, and you may be entitled to significant compensation. We got two decisions from the judge overseeing Sean Call's criminal case that we got to talk about, and the judge, of course, we're referring to as Judge Arun Subian, the judge out of the Southern District of New York federal case. So the first decision concerns videos of the freak-offs, and we've talked about this before on other sidebars. You see, earlier this month, Combs' attorneys had asked the court to order the prosecutors to electronically produce videos of the freak-offs. And remember what the freak-offs are, right? Prosecutors have alleged that Combs would intimidate, threaten, lure women into extended sex acts with male sex workers using force, threats, coercion. That Combs filmed and recorded these freak-offs, and these are key components of the racketeering.
Threats, coercion, that Combs filmed and recorded these freak-offs. And these are key components of the racketeering conspiracy, the sex trafficking, and the transportation to engage in prostitution charges that he currently faces. And by the way, he's scheduled to go to trial in May. Now, the defense wanted copies of these videos handed over to them, not just the ability to view them at the prosecution's office. They wanted copies of these videos for themselves. And I've talked to lawyers about this before. There's a big advantage.
Defense and Shan's lawyers argue that under the federal rules of criminal procedure, if the defendant asks for it, the government has to give a defendant the opportunity to inspect and to copy electronic data that is in the government's possession. And that data, that evidence, has to be material to preparing their defense. And here, Combs' attorneys argued material. The videos of these alleged freak-offs are at the center of the allegations put forward by the government, and they say, look, the government hasn't presented a real, legitimate, solid reason for why they shouldn't be turned over to the defense. It's not like we're dealing with child pornography or
are at the center of the allegations put forward by the government. And they say, look, the government hasn't presented a real, legitimate, solid reason for why they shouldn't be turned over to the defense. It's not like we're dealing with child pornography or classified information where you have to have certain protocols put in place by how that material should be shared or disseminated. And they say, more importantly, these tapes prove our client is innocent. So Combs' lawyers wrote in a previous letter, having reviewed these videos, it is now abundantly clear that they confirm Mr. Combs' innocence and that their full exculpatory value cannot be investigated and used unless they are electronically produced. The 9 videos at issue are the so-called freak-off tapes with victim 1 that the government has repeatedly referenced, causing wild speculation in the media. Contrary to what the government has led this court and the public to believe, the so-called freak-offs were private sexual activity between fully consenting adults in a long-term relationship. Like many Americans in the privacy of their own bedrooms, they sometimes filmed their sexual activity. These videos unambiguously show that the person alleged in the indictment to be victim 1 not only consented, but thoroughly enjoyed herself. And by the way, victim 1 is with respect to that sex trafficking charge. And we believe victim 1 to be Cassandra Ventura. This is Diddy's
commercial ex-worker in that hotel room, and that's what she was running away from. Now their letter to the court said that victim 1 was in these videos, quote, was happy, dominant, and completely in control, and that there's no evidence of coercion or threats or manipulation. Again, IES. Trafficking. The defense said there's no evidence that anyone is incapacitated or under the influence of drugs or excessive alcohol consumption, meaning maybe there was some alcohol consumption. There's certainly no evidence of trafficking. Moreover, contrary to innumerable sensationalistic media reports, the videos do not depict sex parties.
And that there's no evidence of coercion or threats or manipulation, again, i.e. sex trafficking. The defense said there's no evidence that anyone is incapacitated or under the influence of drugs or excessive alcohol consumption, meaning maybe there was some alcohol consumption. There's certainly no evidence of sex trafficking. Moreover, contrary to innumerable sensationalistic media reports, the videos do not depict sex parties. There are no secret cameras, no orgies, no other celebrities involved, no underground tunnels, no minors, and not so much as a hint of coercion or violence. Far from the government's lurid descriptions, the videos show adults having consensual sex, plain and simple. At bottom, this case is about whether victim 1 was or was not a willing participant in her private sex life with Mr. Combs. The videos confirm that she plainly was. So, consent appears to be the main defense to the federal criminal charges. And that would make sense, right? Because the idea would be, did they engage in sex? Yes. Did he transport her across state lines? Yes. But as long as there was no threats or fraud or coercion or illegal, sex acts or commercial sex acts, it's fine. It's legal. It's not sex trafficking.
While there's been a lot of talk about celebrities involved in these episodes and, like he said, secret cameras and tunnels, they argue that a lot of this is speculation. The speculation about, what's on the Diddy tapes, they say no. All of it's not true. We got to be clear about what these tapes are and what these tapes are not, and they also highlighted something else. The defense also said these videos, another reason why I think we deserve them and deserve copies of them, is they were taken from victim 1's device, not Sean Combs. So the idea that he kept these videos as collateral or blackmail as a form of power and control over victim 1 doesn't hold water, and basically they asked the court to amend the protective order that has been put in place in this case to allow the prosecutors to turn these tapes over to the defense. This was an order from the court that dictated how information would be disclosed and shared and disseminated by the defense and prosecution, and as the defense called out in their letter to the judge, the protective order made this video evidence, again allegedly of the freak-offs, quote, available for inspection only and not electronic produced. They said, court, you need to amend this, we deserve the tapes. And they also argued, by the way, that we need these videos, we need copies of these, because they said that the audio on the tapes you can barely hear it and the lighting is very bad, that the images are dark and grainy, so we need our own experts, our own defense experts, to enhance the quality and analyze the metadata. So now back to Judge Arun Subramanian's order that came down yesterday. What did he decide? Well, Judge Subramanian denied the defense's MO to amend the protective order, but without prejudice, meaning this issue could be revisited. So Subramanian order reads, quote, while the government objects to handing the videos over, they provide several options for defendant to consider that would permit the defense to view the videos, access the information they're looking for, and even allow them to manipulate the videos as they see fit. To the extent these options are insufficient, the defense may propose other options to the government. It doesn't appear that the defense did this before raising the issue with the court. The parties should have these discussions, and if they really reach an
protective order, but without prejudice, meaning this issue could be revisited. So Subramanian's order reads,
possession of the videos despite the options furnished by the government. So Combs and his team, they don't get the tapes, and Judge Subramanian seems to be, calling out the defense a bit, like, you really could have worked this out with the prosecution before, right? Did you really need the court to step in? Did you even ask the prosecutors how you might be able to regularly view and analyze the tapes as you see fit to prepare for your defense? So look, this issue may be revisited if they really can't figure out a way to make all of this work. And look, it's not surprising that the judge just won't allow the defense copies of these tapes and amend the protective order. I mean, essentially we're talking about sex tapes, right? Key pieces of evidence in this case is very private, very sensitive. Got to be careful about how this is handled. And let's not forget, Sean Combs is in hot water right now. He was denied bail again, partly because he was accused of violating.
Did you really need the court to step in? Did you even ask the prosecutors how you might be able to regularly view and analyze the tapes as you see fit to prepare for your defense? So, look, this issue may be revisited if they really can't figure out a way to make all of this work. And look, it's not surprising that the judge just won't allow the defense copies of these tapes and amend the protective order. I mean, essentially, We're talking about sex tapes, right? Key pieces of evidence in this case. It's very private, very sensitive. Got to be careful about how this is handled. And let's not forget, Sean Combs is in hot water right now. He was denied bail again, partly because he was accused of violating the Bureau of Prisons rules by improperly using other inmates' phone access numbers, improperly contacting people, and allegedly trying to reach out to victims and witnesses while he's locked up at the Metropolitan Detention Center. Can he and his team be trusted with copies of these videos? Now, to be clear, the judge didn't say that in his order, but you have to wonder if that is ultimately a point of consideration in not handing these tapes over to Sean Combs and his team. And with that in mind, this is not the only issue that came up. There was another ruling from the judge we got to talk about. There was another thing the judge decided just now. We want to talk about it, and it concerns the same issue. It concerns the tapes. You see, the prosecution weeks ago responded to the defense's letter, but they didn't focus so much on turning over the alleged sex tapes. They didn't want to turn them over, but rather what they focused on and what they accused the defense of is they alleged the defense violated the protective order. They argued that the defense revealed just way too much about the content of these videos, even though the defense redacted certain portions of the videos in their letter to the court that we all saw. It was a public letter, but they say that's not enough. The prosecution argued that under the protective order, no portion of the videos should have been filed on that public docket without being filed under seal, basically meaning the public won't have an opportunity to see it. Or they shouldn't have filed it without the defense first talking with the government as to the proper designation. They say the defense did neither. So instead of talking with the government about this or redacting all of the content related to the videos, the defense, they argued, left unredacted descriptions and characterizations of material in these videos that was designated attorney eyes only, AEO. They argued that by doing this and kind of telling the world what these videos, in their opinion, show, this threatens the privacy of the victims in this case. And they asked the court to remove it from the public filing, have it be refiled with full redactions. The defense objected to that. So they responded in a follow-up letter to the judge. They said, okay, tell you what, we'll agree to make redactions, but judge, and we need you to allow us to refile this letter, but with narrower redactions. They argued that what the government is asking for is way too overbroad, that we shouldn't have to redact everything. That, look, judge, the government started this. The government has been quite specific about details of freak-offs and what they're alleging the evidence will show. We have a right to respond. We have a right to provide our own description, our own characterization of what these videos are. And the defense also argued that there is a presumption of the public having access to all the details about these videos. Again, videos of freak-offs are the government's key piece of evidence. The public has a right to know, and Combs' rights are being compromised by not having the proper access to this video evidence. So in their letter, the defense writes, indeed, the public can only have confidence in the conscientiousness, reasonableness, or honesty of judicial proceedings if the documents on which judges rely are publicly available. And they say the government provides no adequate rationale for sealing this information. In fact, let me read you this part in its entirety because I think this is a key to what the defense's argument was, and then I'll tell you what Judge Arun Subramanian decided. But the defense wrote, while victim one may have privacy interests that justify keeping the videos themselves under seal at this stage, including details of the content of the videos, the fact that victim one was filmed while participating in the so-called freak-offs is public information. Indeed, the government has publicized that these were extended sex acts with male commercial sex workers and elaborate and produced sex performances that were electronically recorded. The government has publicized gratuitous details, including the use of baby oil, lubricant, extra linens, lighting, room damage, delivery of IV fluids. The government even held a press conference publicizing the seizure of more than 1,000 bottles of personal lubricant and baby oil. And the government has publicly asserted that during the freak-offs, alleged victims were subjected to physical, emotional, and verbal abuse, including being hit, kicked, and dragged, and that alleged victim claims are corroborated by videos of the freak-offs. Faulting the defense for characterizing that same evidence as exculpatory and consensual is an unfair double standard and demonstrates the government's intent to mislead the public and the court. To accept the government's broad reading of the protective order would turn it into a tool to shield the public from any interpretation of the evidence that could be favorable to Mr. Combs. After the government has been able to tout its own inculpatory interpretation, the result will be an unfairly polluted jury pool manufactured by the government's misleading narrative and widely disseminated by the press. Okay. Now to the judge's order from yesterday, and here is what Judge Subramanian wrote. Quote, "The protective order is clear that the defense shall not share any AEO material, attorney's eyes only material, or the content of the AEO material with any other persons. The defense's original letter, which the court ordered stricken from the public docket, did not redact numerous descriptions of the content of the videos at issue, which have been designated AEO pursuant to the protective order. These descriptions are also appropriately sealed under the test in," and then they cite a case, but the judge says this,
"Content of the AEO material with any other persons. The defense's original letter, which the court ordered stricken from the public docket, did not redact numerous descriptions of the content of the videos that issue which have been designated AEO pursuant to the protective order. These descriptions are also appropriately sealed under the test and then they cite a case, but the judge says this. But to the extent certain of the government's proposed redactions don't relate to the content of AEO material, the defense's original letter can be refiled with those specific sentences unredacted. In other words, defense, you didn't redact what you should have, okay, namely the descriptions of the videos or your characterizations of the videos. That was attorney's eyes only, not for the public to see. We actually removed that letter from the docket, but I will tell you it's already been, heavily reported in the media, so how much good is that?" But Judge Subramanian seems to leave a little bit of opening here, that if the government proposes over redactions, if the redactions just go too far and they're covering things that really don't need to be attorney's eyes only, then those things don't have to be redacted. By the way, before we finish things up, I just want to quickly lay out something else. So there was a big bombshell that came out recently about freak-offs. I'll get to that in a second, but just so we all are clear about what,
as laid out by the prosecutors in Combs' criminal indictment. Combs and other members and associates of the Combs enterprise wielded the power and prestige of Combs' role at the Combs business to intimidate, threaten, and lure female victims into Combs' orbit, often under the pretense of a romantic relationship. Combs then used force, threats of force, and coercion to cause victims to engage in extended sex acts with male commercial sex workers that Combs referred to as, among other things, freak-offs. Freak-offs were elaborate and produced sex performances that Combs arranged, directed, pleasured himself during, and often electronically recorded. In arranging these freak-offs, Combs, with the assistance of members and associates of the Combs enterprise, transported and caused to be transported commercial sex workers across state lines and internationally. Freak-offs occurred regularly, sometimes lasted multiple days, and often involved multiple commercial sex workers. During freak-offs, Combs distributed a variety of controlled substances to victims, in part to keep the victims obedient and compliant. Sometimes, unbeknownst to the victims, Combs kept videos he filmed of victims engaging in sex acts with commercial sex workers. After freak-offs, Combs and the victims typically received IV fluids to recover from the physical exertion and drug use. By the way, a little side note, I keep getting this question, isn't it interesting that he's going to trial for racketeering and yet he's the only criminal defendant? It is interesting, right? He can't engage in a racketeering enterprise like this, or an alleged racketeering enterprise like this, by himself. So you imagine that there will probably be alleged co-conspirators who are testifying against him. I don't see, is it possible that other people might actually be indicted alongside him? Maybe, but at this stage, seems unlikely. I don't know, just an interesting point. It's the same thing that we talked about with Ghislaine Maxwell, right? Anyway.
That there will probably be alleged co-conspirators who are testifying against him. I don't see, is it possible that other people might actually be indicted alongside him? Maybe, but at this stage seems unlikely. I don't know, just an interesting point. It's the same thing that we talked about with Ghislaine Maxwell, right? Anyway, let's not forget that prosecutors allege that these freak-offs, though they weren't just happening years ago, right? In one of the letters to the court, they wrote, indeed, since at least in or about January 2024, when the defendant was unquestionably aware of the criminal investigation, the evidence shows that he is engaged in multiple freak-offs, some including the interstate transportation of individuals.
Was an alleged male sex worker identified as Nathan. Now, Nathan, in this report, claims that Combs actually contacted him to participate in a freak-off in 2019. He claims this was out in Miami at the One Hotel, essentially a threesome, 2 men and a woman. Apparently, though, that didn't happen, that specific freak-off event or alleged freak-off event, but Nathan says he was paid between $2,000 and $5,000 for these types of sexual episodes, and that freak-offs were, quote, ritualistic.
So that didn't happen, that specific freak-off event or alleged freak-off event, but Nathan says he was paid between $2,000 and $5,000 for these types of sexual episodes, and that freak-offs were, quote, ritualistic, and that Combs would be there. He would choreograph the whole thing. He would watch, quote, he would pretend to leave the room, but like go around the corner and crawl in the room on the floor and peek around the corner or use the mirrors. This is what Nathan claimed. Really creepy obviously. Because it's like your girlfriend. Why do you even have to do that? He claimed that these episodes would occur at places like hotel rooms in Miami, New York, Los Angeles, that there would be warm baby oil, that he was even allegedly drugged during a freak-off. I mean, what he's alleging here is entirely consistent with what prosecutors are alleging now. We don't know if Nathan is going to be a witness at the federal criminal trial that's scheduled for May, but I imagine that is probably consistent with testimony we will hear potentially from other alleged sex workers, and if there are paper trails, money,
the defense
travel invoices, hotel invoices, that is all going to help the prosecution prove their case, particularly the prostitution and sex trafficking charges. Now, though, the defense has seemed to suggest in prior filings that there are witnesses who will rebut this, and they will say that everything was consensual, that everything was on the up and up during these, and I don't think they're running away from the term freak off. So again, goes back to the idea of consent. We shall see how this unfolds. But again, big decisions by Judge Arun Subramanian in this criminal case. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us, and as always, please subscribe on YouTube, Apple Podcasts, Spotify.